on the. All eyes.
Please be seated. We now come to the third and last case on our docket today. That case is State Farm Mutual Automobile Insurance Company versus Hudnall, case number 240922. And counsel for the appellant, if you'd be kind enough to state your appearance for the record, and also let me know how much time, if any, you would like for rebuttal.
Good morning. I'm Warren Klobnik on behalf of State Farm. I will reserve 5 minutes for rebuttal, and I am not very tall, so I will try a little bit.
Okay. Thank you.
Again, may it please the court, I'm Warren Klobnik on behalf of State Farm. This is an appeal of a judgment in a case for uninsured motorist benefits. The policy amount was $100,000, but judgment was entered in the amount of the full verdict of about $4 million. And I'd like to begin, if I could, with what we briefed as our second issue pertaining to the amount and form of the judgment. That was our second issue, but I want to make sure that this is covered to the full degree that the court needs it to be, because this is an important issue. It's recurred, as the court conceived, by the fact that it's been handled last year by the second DCA. The long-standing rule in Florida is that a judgment against an insurance company for uninsured motorist benefits is properly limited to the policy limit unless and until there's determination that the company acted in bad faith. That has not happened here. We're only at the beginning stages of the bad faith litigation. So it was error as a matter of law to have a judgment entered for the full $4 million plus verdict.
Mr. Lee would tell us that all that case law changed with Fridman. So what say you?
I say that Fridman didn't change this, as Finson tells us from the second DCA last year. Fridman was an important case. Fridman told us that when you have an uninsured motorist case, that determination of damages becomes the binding measure of damages in a future bad faith case. And what they said you can do is, you can include that number, you can put it in the judgment so that it's of record as the binding measure of damages. But Fridman didn't say that you entered judgment in the full amount of that verdict. Fridman actually had the judgment that was entered in that case reproduced in the opinion as the judgment that they endorsed.
And I saw that, counsel. So would it be State Farm's position, if we were inclined to find that your argument has merit, to say that the trial court needs to follow that template, the Fridman judgment template? Is that what you're asking us to do?
Yes.
Following the exact format, I've got it up here, the format the Fridman court referenced in the beginning of the opinion, you would say that it should have happened just like that in this case?
Or to that effect, sure. It doesn't have to be word for word, but that is the type of judgment that we think should be entered in a case like this. We don't, it's well established in Fridman that that is the binding measure of damages. There was a period of time when insurance companies thought that they got a whole redo in the UM case. Fridman put that to bed, and we're not saying we want a redo. But the binding measure of damages shouldn't be the amount of the judgment right now. As of right now, there's a judgment of record, an open judgment against State Farm in this case for over $4 million. State Farm doesn't owe, it may never owe, and interest is accruing on that. This is the very type of judgment that Finson told us last year you can't have. Finson explains that Fridman, it's a misreading of Fridman to suggest that this is an appropriate judgment. And I understand counsel thinks that Finson was not correctly decided, but I don't think we've been directed to any point of it that was wrong. I think it's the correct ruling. In my research throughout Florida and elsewhere, I've seen no authority for the idea that you can have a judgment in one facial amount, but executable in some other amount. It's a bizarre judgment, and it serves no purpose, really, because no matter how the bad faith claim shakes out, that judgment's going to have to be addressed in some fashion. If State Farm wins a bad faith case, you've got to vacate the judgment.
So just, and forgive me for the oversimplistic question, but can you just lay out for us a little bit why this isn't 6-1, why half a dozen the other? You mentioned the interest in Indigo, but what difference does it make whether we have it as a judgment or we have it included with the judgment? When the rubber hits the road, who cares?
Well, that's their argument, is what difference does it make? It's only executable. And leaving aside the accrual of interest, which obviously is a thing, a judgment is an adjudication of a debt. Right now, there's a public record document that says State Farm owes $4 million that it doesn't owe. It could have business implications for State Farm. It could have licensing implications for State Farm. You know, they're a massive company, but I can tell you, if there was an open judgment against me for an amount that I don't owe, it would affect my ability to get a home loan, a car loan. It would have all kinds of implications. It's just wrong as a matter of law to have a judgment against them in an amount that everyone knows is not owed.
To follow up on Judge McIver's question, if there was a determination prospectively that State Farm was in bad faith here, would there be entitlement as part of the damages to prejudgment interest, meaning from the time of verdict?
I don't know the answer to that. The UM statute tells us that there is interest owed on unpaid benefits, which arguably could mean the amount of the policy. But I would say this, that's a matter to be addressed by the bad faith judge. I don't see any good reason why the judge in the initial trial should be making any preemptive determination as to what interest may or may not be available in the bad faith case. In fact, there wasn't any determination as to what interest would be available. It was just put into the judgment that way. But if that's a bad faith damage, then it should be addressed there and in that context, is my response to that. I think our position on this is clear. But again, this is a recurring issue, as we've seen. I want to make sure I cover this for the court's consent.
Well, it sounds like what you're telling us, counsel, is we need to write on.
Well, if you're going to reverse, then yes. I think PCRs don't exist. Well, I mean, you could do a one sentence. We reverse for entry of judgment in accordance with the policy on the C fits in to that effect. If you don't reverse on the first point, which I'd like to talk about as well.
Let's hear you on the first one. What is your strongest argument as to the trial?
As to the trial, I'll be candid. Obviously, this business about there's 4 types of evidence, no evidence, all the evidence. I think that has the potential to be misleading. I think there were times along the way when it might have been in some tension with the way the juries are supposed to weigh evidence, but I don't expect Your Honors to reverse based on 25 unobjected to applications of that. I'm asking that you take that into consideration, perhaps. I'm not dropping it formally, but that is not our strongest point on the first one. Where we do have an issue is the improper cross-examination of the defense doctor, Dr. Von Thron. That, I think, is a serious trial error. What happened here is Dr. Von Thron was one of the defense experts. He's the one who did an examination of the plaintiff and found that her injuries were temporary and not the cause of the surgery she wound up having. As commonly happens, the plaintiff attempted to cross-examine the doctor with evidence of a financial bias by showing that he's done so much work for State Farm. And the way this played out was through several pages of the cross-examination, beginning on page 1307 to approximately 1308 or 1311, so 4 or 5 pages maybe of cross-examination. It played out with plaintiff's counsel telling the witness that you've recovered over $400,000 from State Farm over a 2-year period of time. And this was done with reference to a document that counsel was holding that was being presented as if it was a real tax document pertaining to Dr. Von Thron. It was not. There was no evidence ever established that Dr. Von Thron, as opposed to the 35 doctoral practice where he worked, had ever recovered any particular sum of money from State Farm, let alone $400,000.
The argument, as you know, in response to that is, well, Dr. Von Thron took care of it. He rectified this problem by pointing out that the tax ID number was not for him personally, it was for JOI. So what do you say about that?
It was not cleared up well. It was not, first of all, it was not as steadfast as they say. If you read it, Dr. Von Thron is saying, that can't be for me, that doesn't make sense, but I'm not in a position, I'm paraphrasing, I'm not really in a position to agree or disagree because I don't know where you're getting that information from. And it was never definitively put to bed. Basically what we have here is an accusation that he's made $400,000, a somewhat denial of it. It never got, from the jury's perspective, he's being accused with a document that he's made $400,000. They're hearing him deny it tentatively, but can't really do it. And it was
why, and I know track cases is hard, it's a difficult thing, I used to try cases. Why didn't the State Farm lawyer get up on redirect and take care of this?
I've got the record like Your Honor does, but we had an overruled objection. Maybe she felt that, given the degree to which he'd been beaten up with this, it's best to just leave it be. I know it's
Was there anything that you can see in this record, counsel, that would have prohibited her from going back with a document? And I don't want to put questions in her mouth, but is this the first time you're seeing this document? Yes. Have you ever seen it before? Of course not. Does that appear to be JOI's tax ID number? Yes. Is that yours? No. I mean, wouldn't that put all this to bed?
Perhaps. Maybe she could have done it this way. But, again, I'm not in the nature of second guessing the way my trial counsel handles things. Where we were at this point was there are 2 overruled objections to this. A document that she didn't know what it was or where it came from. I really can't say that if the suggestion, maybe Your Honor's not suggesting this, that, could it have been cleaned up differently? Maybe. But we're on appeal from 2 overruled objections that should not have been overruled. And it was harmful. And this came back in closing argument. And in terms of it being cleaned up, here's how it was.
I guess my point, and again, I know it's difficult. I know it's hard to try cases. But the point is that it wasn't fully elucidated, that Dr. Von Thron wasn't definitive. Sounds like he was close to being definitive had there just been a little nudge in the right direction. So that I just have, that this gives me a little pause for how radioactive this was to throw away a trauma.
It was radioactive, and let me address your response. It was not as definitive as it could have been, and I think bringing it up more to deny it further on redirect, I don't know if that solves the problem, because all we have at this point is a denial of an accusation. He can deny it so many times, but the jury has already heard that he's being accused of having received this. There's a case I want to tell the court about that I think is helpful in this regard. I cited it in my reply brief. It's a Florida Supreme Court criminal case called Evans, and it is 177 Southern 3rd 1219. And that case tells us that it's improper to insinuate impeaching facts without evidence. And what happened in that case is it was a man who was being accused of killing his ex-wife and his boyfriend. And allegedly as a result of some stalking that preceded it. And the question is asked by the state, isn't it true that you hired a detective to investigate these people? And he says no. And he denied it. It was a flat denial, clear, unequivocal denial. It was still held to be error that worked towards a reversal for having asked the question without evidence to back it up. So I think we're not necessarily looking at it the right way. We say, well, didn't the witness clean it up enough? The witness is just denying an accusation that's being leveled at him. He can deny further on redirect, but plaintiff's counsel stood up and told him that he recovered $400,000.
Is there any evidence, I know this is hard to prove, any evidence that Mr. Block knew it didn't apply to Dr. Von Thron?
I don't want to accuse someone of that.
Well, and so that's this judge's point. Yeah. If there was no Sienna, he thinks it may be Dr. Von Thron's tax ID, and then Dr. Von Thron says, oh, no, there's no way.
Yeah.
I billed State Farm for all those CMEs.
Well, we don't know, but there's certainly no evidence that he maliciously lied to the jury. But that type of, what you're getting at is whether a good faith basis for the question.
Correct.
And Evans addresses this. Either Evans or the case it cites addresses this, that good faith and bad faith doesn't really matter here. You have to have evidence to support it. And I think that's what goes to the legitimacy of the question, is if you don't have evidence to support what you're saying, either you don't have it now or it doesn't exist.
Well, sorry.
No, I was just saying, I think he thought he had it. You don't have any indication otherwise, but he thought he had it in his hand.
Right. Saying, for the sake of argument, if the tax ID number had been his?
If the tax ID, but again, I don't think the question is good faith or bad faith. He never had the evidence to back it up. He was wrong. I don't think the scienter matters in this context. He's not on trial for it. Was there evidence to support the question? And again, if you look at the cases that are cited in Evans, whether they had good cause to believe is really not, I don't think, the issue. There was never going to be evidence of this, whether it was through his office's negligence in putting this together or whether it was intentional.
And you know this, in the course of a 5-day trial, there are any number of things that come up through the fault of really no one, that may be something a little different than they anticipate. I mean, that's the nature of this give and take in trials. And
Yeah.
so I think what I hear my colleagues saying is we just don't have any evidence in this record that this was intended in a way to be different than what this lawyer believed it was.
Well, a few things about that. One, I don't know that it matters. There was never evidence to support this, whether he thought it was true or not. But the other point, too, is,
Well, shouldn't that go into the analysis, true? It seems, at least to this judge, that maybe it should. That it would be, I'd be a lot more inclined to hear what you're saying if everyone agreed this wasn't what he proposed it to be, and he took the position he took.
well, and I can understand that. Certainly, if we could show that he was openly lying to the jury, you'd be more inclined to do this. But let me address it this way then. By the end of the examination of Dr. Von Fraud, counsel should have known that it was not correct. But in closing, he comes back to it. In closing, it said, Dr. Von Fraud, we've talked about him in his practice. Even if it wasn't him, okay, so it's not a concession it wasn't him, it's even if it wasn't him, it's his practice. And then, the next page, 1539, he's been working with them for years, made hundreds of thousands of dollars for years. So certainly by closing, if it was mistaken before, counsel now knows it's false. And he's reiterating it this way in closing argument.
And there was no objection to that, correct?
Unfortunately, no, there was no objection to that, but given the overruled objections to the examination in the first place, I think this is simply harmfulness that builds on the objected to examination. And I think the case law supports that when you have objected to evidence and it's overruled, the fact that it comes up again in closing is just harm that goes towards that. And it is harmful. I understand it was a multi-day trial, but causation was very much in dispute. This is a plaintiff who had a huge gap in treatment. Causation was disputed by the experts. This was the primary defense expert. It was the only defense expert who'd actually examined the plaintiff. And the jury is being told now that not only are his opinions bought and paid for to the tune of hundreds of thousands of dollars that really were not, but the jury saw him being coy about it on the stand and saying, I don't really know where you're getting that information from. This was error to allow it in, and we know under special, it's only not reversible in that point if there's no reasonable possibility it didn't affect the jury's verdict.
Well, and I'm going to give you a couple more minutes, counsel, but was it improper impeachment if, in fact, JOI had billed State Farm for these CMEs? I mean, how is that improper? Wouldn't that be fair game?
It depends. Well, hypothetically, maybe, but not the way it's being presented.
No, and I appreciate that, but I mean, the error you're claiming this shouldn't have ever been used with Dr. Bonta.
No.
Are you not?
Well, yes, it should never have been suggested to him that he personally, not the practice, he personally made money that he never made. And second, it never should have been supported holding up an exhibit that was a mystery exhibit that didn't actually support what he was saying, but had Dr. Von Fraud's name had written on it.
I guess my point, and I think you understand my point, had Rick Block stood up and said, this is JOI's tax ID between 2015 and 2017, they billed State Farm, you billed your group of doctors billed State Farm $450,000, whatever the number was. Is that improper impeachment?
Well, first of all, I don't know that it was ever even established that the JOI made that money. But assuming it's true, I think it's not, at least in that instance, if that was the case, it wouldn't be false, but we're talking here about the witness's own financial bias. It carries a lot less weight against him if an employer of his is making this money as opposed to him personally.
Which we understand. I think we all get that. But he arguably clarified that on the stand.
Only to the extent he was comfortable doing it in the face of a document. And again, it wasn't as definitive as counsel said.
Wasn't there a definitive answer, and I don't have the transcript in front of me, where he definitively said that's, basically that's not my tax ID number, that's JOI.
He certainly says that. And
I mean, isn't that, Gabe said that, is it not, right there? I mean, for everyone to know it's not his.
Well, that's a denial, but up until that point, counsel is telling him, no, this is a tax document for you. That's what it said specifically in front of the jury. He says, is that JOI's? And counsel says, no, this is yours. So they have a dispute between them. We have an accusation and at best a denial of it. It's never cleared up in any way. And again, it's reiterated in the closing. I think it was improper, and particularly once it should have been made clear to Mr. Block that this wasn't the true facts. To come back to it in closing the way he did, that just drove it home. I see I'm running out of time.
I just have one.
Go ahead, Jeff.
I just briefly, and again, great empathy, trying cases is very difficult. And where's the line though? If there's an opportunity, because there's an opportunity here to essentially discredit, what they're trying to present and really drive that home. And it's if there was error, any errors, made more apparent by not maybe coming back and cleaning that up.
Well,
so at what point is it our obligation to step in and say, well, we're going to fix it because you didn't clear it up and didn't take that opportunity?
Well, that's a fair question, of course. I think where we are is error was committed, it wasn't harmless. And we can only guess what would happen had counsel brought it up. I know there are times, and I've seen transcripts, I know at least one of your honors has been a trial judge, I've seen it before when a judge is reluctant to even give a curative for fear of drawing more attention to something. And I think that might have been where we were. This went on for pages, and to bring it up more may do more harm than good. But again, I think for counsel to have tried to correct it, it's just building more denial on top of denial. And the jury's already heard the denial. It was an accusation that he was denying. And again, what more could have been done on redirect? But
well, that's the point, isn't it? I mean, you just words matter.
Right.
He denied it.
He did deny it, somewhat. But again, it was vacil. It was. I don't know where you're getting that from. It couldn't possibly be me. That's JOI's tax ID number. But in the face of accusations that, no, it's yours. So again, what we're left with is counsel telling the witness that this is his, him denying it. He can only deny it and deny it, but we're still left with an accusation and a denial. And never admitted, I might have more concern for a harmlessness or a waiver type situation if in closing counsel gets up and says, I told you when I was examining Dr. Von Franz, that it was him, it wasn't, it was a facility, but it doesn't matter, and here's why. But that's not the closing we got. We got a repetition that he's made hundreds of thousands of dollars. But to get back to your point, could this have been fixed on redirect? He'd already somewhat denied it as best he could. We were not going to get any further than an accusation and a denial. And it never should have happened, and the objection should have been sustained.
And given what I said before, we did ask you a lot of questions. I will give you 5 more minutes for rebuttal.
Thank you.
That means, Mr. Lee, you've got 7 more minutes if you're so inclined, but you'll have 5 minutes for rebuttal.
Thank you so much.
5 minutes total.
For rebuttal, when he stands back up, he will have 5 full minutes, and that's actually 7 minutes and 8 seconds for Mr. Lee that we're giving back to him. So if you would make Mr. Lee's time 27 minutes, unless you want 8 seconds, Mr. Lee.
I'll be fine, Judge.
All right, please.
Hopefully I won't even take 27 minutes, but good morning to the court. My name is Brian Lee. I'm representing Catherine Hudnall in this appeal. I want to start from the position that when we look at this appeal, really dealing with sort of 2 baskets here. We're dealing with what happened at the trial versus the judgment itself. I'll take the trial first and just run through it and obviously answer the court's questions as I go. But when we look at this case, there are a few objections. The court and counsel's already talked about it, but the vast majority of what we're talking about here and what they are moving for appeal on are unobjected to comments. And that is something that, as this court knows very well, you have to have fundamental error. You have to be looking at fundamental error when we're talking about unobjected to things. None of this, frankly, let me just go from the beginning. The first thing that you have to look at for under Murphy is whether it was improper. We're saying that none of it was improper. And the comments that were made by Mr. Block through the trial were not improper in the context of the case, the evidence, what he was telling to the jury. But even if you kind of go beyond that, the other aspects of Murphy are, in a word, onerous on the other side. You have to show incurability. You have to show that the comments were in violation of the public trust of a trial, that a new trial is necessary, right, for the public to have trust in the system. This court recently in Sloan versus Fisher talked about how far comments have to go. Even in that case where counsel were saying things like jury nullification arguments, that they want you to not follow the law in making that. Even that was not and what amounted to fundamental error. So if we're talking about just the unobjected to comments, they do not rise at all even close to that. But when we talk about then what was objected to, I think it's important to figure out, or for the court to know, that the objections here were not even proper when they were made. And what do I mean by that? I mean that the objections themselves were to things that in one instance, that the trial court, Judge Feltel even pointed out that that's not really an illegal objection to what you're saying there, but they were also objections that were tangentially, we're talking about things that actually weren't going on. And I'll look at the actual Dr. Von Thron testimony for that. When Mr. Block started his cross-examination, he went right into what we call, I'm sure the court knows, is financial bias. There are a couple things that need to happen, though, if we even go before trial for financial bias discovery and that type of testimony to come in. Number one, normally you're doing what we lovingly call Bocher interrogatories, right? You're getting that information. But even if you're not doing that, part of what every trial judge has in their orders is you have to give over exhibits. And we know from the Florida Supreme Court and probably every circuit that we have, every district that we have, is that impeachment is one of those things. And so I find it, now, I'm not telling the court that we have that in the record. We don't have a listing of all the exhibits and every single exhibit was given. But in context of that, I find it interesting that when Mr. Block starts talking about this particular type of discovery, and he tells Dr. Von Thron, you've been paid the $442,000. It isn't at that point that defense counsel objects. Defense counsel doesn't even object until Dr. Von Thron's now being shown a document. Now, she does object and says it's improper impeachment, which we don't believe it is. She does later on after Dr. Von Thron has definitively said, that's not me. And from the record, which they cited to, says, there's no way I did that much for State Farm. That has to be JOI. I'd be shocked, right? So Dr. Von Thron, even up before Mr. Block then attempts to have the record and give it to him to refresh recollection, he's denying it then. And then when Mr. Block does that, he gives it to State Farm counsel. State Farm counsel doesn't object that, well, I've never seen this document before. Where did you get it from? That wasn't one of the exhibits. Shouldn't say that. She says, well, you wrote something on top, and I think that is an inaccurate document because you wrote something on top. Again,
Dr. Von Thron.
Dr. Von Thron, right? And I mean, I don't have it in front of me, but I'm sure, as most of us do, when we were doing trials, we write stuff, on our thing and say, hey, make sure to ask him this, or this is for Dr. Von Thron, because Jacksonville Orthopedic Institute does bill for their doctors. It doesn't make a lot of sense. Again, I'm going outside, but it doesn't make a lot of sense for Dr. Von Thron to have done work through JOI and bill his own tax ID number. So what am I getting to? What I'm getting to is that there is nothing in the record that says that those numbers are not accurate as to Dr. Von Thron. It is very possible that there was this record that was got through discovery, through otherwise, of the CMEs, the compulsory medical examination that Dr. Von Braun did during that time, which were billed through JLI's number. But they are still Dr. Von Braun's exams that he did. That is absolutely possible. Could have been the reason why Mr. Block felt so confident. I know this court knows Mr. Block and Judge Jay and Judge Cobain. Mr. Block's not going to do things that don't have a basis. And so when he does that, we can glean some clues from the record that there wasn't an objection to the amount. There wasn't an objection that...
Bottom line, what I hear you saying, Ms. Foley, there was no objection from counsel saying this is a document she had never seen before. There was no objection from her saying it was deceptive, fraudulent, surreptitious. She was concerned with what had been written on top, which goes to the point of whether this was JOI as a group or Dr. Von Braun individually, correct?
Correct.
And ultimately, Dr. Von Braun, at least from his vantage point, says this was for the group because of the tax ID now.
And he does. And there's two different scenarios. It could have been the entire group that was over, or it could have been Jackson Orthopedic Institute billing for his particular ones. I'm speculating here, but presented with a witness that's saying, no, that's JOI's tax ID number, and those are not mine. Mr. Block, as the record shows, pretty cleanly cut off that line of questioning, because he may be sitting there saying, well, are these all his exams? Dr. Von Braun very specifically said, those aren't mine, that's JOI's number, that's what JOI billed for all 30 of their doctors. That's what the jury heard as far as evidence. As far as what Mr. Block argued to the jury, we know that Judge Feltel told the jury that argument's not evidence. You have to rely on what the witnesses told you, and you have to rely on all the things that trial judges tell jurors every day.
And the statement by Mr. Block in closing, rebuttal closing, was not objected to.
It was not, no. And again, I harken back to, if this was a situation, again, I'm speculating here, but if this was a situation where that number was absolutely wrong, and it was for JOI entirely, or for not one doctor, but many doctors, defense counsel didn't do anything to show that to the jury. Didn't get up, didn't talk about it, didn't object to it like that. And so the court can take from that as it can, as to the legitimacy of the numbers in the first place. Because if the numbers themselves are legitimate, then the way that Mr. Block did it is not improper in any way. So I then want to move on, unless the court has another question for me, to the final judgment, to the way that it was done.
Mr. Lee, could
Yes.
I beg your indulgence for 1 second on a question that probably wouldn't affect the law or the outcome of the case, but just to give it some context. Sort of the same question I asked of opposing counsel. For your client, why does it matter? Whether it's as a judgment or included with the judgment, what effect does that actually have on your client?
Sure, and the simple answer is that the law regarding interest running on judgments is not as clear as we would want it to be. The law that talks about when you put judgments together and when courts do judgments is that interest runs from the point of when a judgment's done. There are cases, and I know that we didn't really get into it, but there are cases that are talking about, and they were briefed to Judge Feltel as to why, that the defendant was taught, State Farm is saying, hey, we know those cases, but we don't want you should only do the lesser amount. Why it's important is that if the judgment is done the way that State Farm has it done, where it's not, where there's nothing in the judgment that talks about when interest should begin, if that happens, then later on, after a bad faith case, there's no mechanism for a trial court to then go back and say, well, I really interest really should have been running from there. That would be in a positive law.
But that's no mystery. Mr.
It is.
I mean,
Sure.
you know what the verdict happened. I mean, if there, and you heard me ask the question, that if there would be entitlement, and I don't know the answer to this, in the bad faith claim to prejudgment interest,
Right.
then you would be able to toggle it back to the very moment that the jury came back, would you not?
That isn't as clear as what we would like.
Well, the clue you're looking for deals with whether that is an element of bad faith damage or.
No, Your Honor. I know it is an element, interest, but there is and I don't think it's been really fleshed out, frankly, in the law, but there is this not confluence of two separate things. The bad faith statute, yes, absolutely says that you are able to obtain interest. But the interest law talks about when interest starts running.
Well,
So-
you have.
And that's a difference.
You've got argument. I mean, and it's property of saying, where you make a demand on another party. Not a jury verdict, not a judgment. You get interest in those cases, correct?
I believe that the interest, they talk about interest from the point of when, yes, I think when bad faith occurs, that could be an argument, but when we're then talking about judgment interest, that's a separate thing. So there's up until the point of bad faith, and again, it's difficult how they do these interest calculations for that. But I think at the end of the day, just sort of cut through, I understand what you're saying, Judge. When we look at Friedman and we look at 21st century,
Well, and let me ask you about.
They talk about
we've got the template.
Sure.
I mean, Friedman gave us I've got it, I asked him about it. I mean, we've got a judgment. Why shouldn't we follow what the Supreme Court of Florida has said? This judgment works.
because the template under Friedman, it talks about, it is unclear as to exactly how to structure the document. It talks about what it should be, but
Yeah, I mean, why wouldn't it be precisely what the trial judge did in Friedman? Which
Sure.
starts off the opinion.
right, but I think that it could be, and I'm saying that, all due respect, it could be that, but what Friedman was doing, and the issue that was in Friedman was whether the way that the trial judge did it was an abuse of his discretion. They weren't saying, and I think they didn't say, that this is the form to use. This is what you should do. They said that the way that the trial judge did it wasn't an abuse of its discretion to do.
So it seems, isn't that the safe harbor? From an appellate standpoint? I mean, if they said that form works, why wouldn't we do the same thing?
Because just because one form works and the Supreme Court says that works doesn't preclude other forms from working too.
No, I understand.
And
from our vantage point, and
Sure.
Patton apparently did the same thing. I mean, Patton, the judgment was only for the amount of the policy, correct?
It was, yeah.
And apparently much is made of Judge Gross and Patton, and they commend him related to what he did in Patton. And so following either one of those templates would seem to work, according to the Supreme Court in Friedman.
Well, that is true. But I also believe that following what the court did in this case also works. There's nothing that we have from the Florida Supreme Court that's wrong, what the trial judge did in this case. In fact, we know, again, we're talking about 21st century, the 4th DCA looked at that under the same type of argument that it was an abuse of the trial court's discretion and found that it wasn't. And reviewed Friedman and said, look, this is what is contemplated with
What do you do with the argument, fairly compelling argument, that all of that is dicta? What the 4th DCA did is dicta.
Well, I don't agree that it's dicta because they're talking about the form of it. Yes, it was an appeal and it was talking about other things that were there certainly, but they are still talking about the form. If this court were to write on this subject and there are two different things that they're looking at, that the court will be looking at, whether the motion for new trial should be reversed or whether the final judgment, and you wrote on both things. I would not be saying that, well, the part that you wrote on about where the final judgment was an abuse of discretion is dicta. Because that was something that was brought up. It was part of the case. And so 21st Century did not just say, oh, by the way, we're just going to talk about this because no one brought it up. But we're just going to talk about it and say this is what we think. This was something that was brought up. And so I don't believe that is what I would say is dicta. 21st Century very clearly did an analysis of Fredman, what it said, and then looked at the trial court order, which is the exact same order. I don't think there's any difference of the structure of what it did, and said that is perfectly fine under Fredman. And so what we have in this case is we have Fredman saying, sure, that this form, fine. We don't find it was an abuse of discretion to use it. We have another court, a lower court, fourth, saying, we think this form is fine to use. 21st Century has not been overruled by the Florida Supreme Court. The Florida Supreme Court has not said that the form that Judge Felto used in this case was wrong. There has been no for it. Now, do we have a case? We have a court that said yes, we did. The second district said in Frenson that they think that 21st Century misapprehended or misapplied Fredman. We disagree with that. We believe that it's consistent with that. And so when we're talking, and that's, I think, the critical difference that I don't believe the second district looked at when they were making their decision, is that Fredman did not say, the Supreme Court did not say, this is the form that you're going to use. Didn't say it. And when 21st Century used that analysis,
well, the Supreme Court said this form is just fine. And, oh, by the way, if you have any questions, look at Patton. And that's the way the Patton trial judge did it. And look at Judge Gross's opinion, because he's really smart. And that's the bottom. So I'm just having trouble with getting around Fredman and Patton.
Right, Judge. And what I would say is, I'm using an analogy. The Florida Supreme Court uses model jury instructions. They tell trial courts, here are the model jury instructions you should use. What they don't do is they don't say, these are the only instructions you use, and these instructions cannot be changed in any way. So, and as the court knows, being trial judges, that happens all the time. Where something happens, where a fact or some situation occurs in a trial, which is very fluid, that a model jury instruction should be changed. And this court and others have said that is okay. A model jury instruction given by the Florida Supreme Court does not mean that you have to use that in every situation. Nobody.
Does it cut both ways for Mr. Lee? You're saying that this model was not error. Is it not error to go the other way?
Meaning that if the trial judge were to have gone State Farm's way, and we are appealing that, is that what you're saying?
Right.
I mean,
would you stand by the same argument that there's no mandatory model, so it's not an abuse of discretion for the judge to go there?
I would expect that they would be doing the argument that I'm doing, and I would be on the abuse of discretion standard, which would be a owner standard for me to overcome. So, and frankly, that was something that was going on, right? So I do, yes. I mean, in many times I think as a fellow counsel, we sort of could switch arguments if we were on the other side. But yes, at the end of the day, I think you're right. I think that it would be reasonable if I were appealing and saying that, well, State Farms is not the way you're supposed to go. If there was an opinion by this court that said, well, Fredman really didn't tell us the form to use, and we don't find an abuse of discretion, I'm not sure how much I'd be in accord with that. That's what we have here. We have this court not looking. We have this court looking at a trial judge and the way they did it, and deciding whether that is against the law to do it that way. And there is nothing that says it is. Now, there is a second district court case. There is in Fenson that says, look, we think it should have gone the other way. But this court obviously is their own court, and the fourth district has already said that too. And so this court, if it wishes, can lend its pen to that situation, because we have not had the four Supreme Courts otherwise. So that's the argument for that, Your Honor. Hopefully that answers the questions properly. I just want to end with, unless there's any other questions on any other points, what I put in my brief and what I use very often is that parties are not required to have a perfect trial. They are required to have a fair trial. That's been in Florida law for decades, maybe even longer. And there's nothing about this trial where State Farm did not have a fair trial. They didn't object to the things that they're saying now. When they did object, it was for other reasons. There was nothing within the trial, or what Mr. Block did, what the trial court ruled, that rises to the level of reversing on this record, especially when this court starts and I think ends on whether Judge Feltel abused his discretion in denying it. We believe he did not. And so we would ask the court to affirm the final judgment, and affirm the final judgment in the manner that it is written. Thank you.
Thank you, Mr. Lake.
Okay, please, the court. We've been hearing a little bit about abuse of discretion. I think both parties agreed in their briefs that de novo was the proper standard of review for whether it was appropriate to enter a judgment in this fashion.
And I was going to ask you that very question. That is the standard.
Yeah. I don't think the judge had, if it's wrong to enter a judgment for more than what a party owes with interest accruing on that, that's legal error. And it is a legal error. There's no authority that says you can enter a judgment for more than what a party owes and have interest running on that excessive amount. I think counsel's point that there's some uncertainty in the law of interest, I think what he's talking about is what would be awardable in the bad faith case. And as Your Honor, Judge Jay, what you pointed out, is all of this is addressable in the bad faith litigation. If interest should run back to the date of the first verdict, the bad faith judge can do that. If it should run back to some prior point in time, the bad faith judge can do that. There's no appropriate way that the judge in the UM trial is preemptively deciding what interest might be awardable in a later case. It's just not appropriate as a form of damages right now. If State Farm is found to not be in bad faith, none of it has any bearing here. So that's the way that should be addressed. As far as 21st century goes, of course it's dicta. Vinson confirmed that it's dicta. 21st century is an interesting case. 21st century, apparently the judgment was entered along the lines of what counsel is saying, but that wasn't the issue on appeal. That was the starting point for the judges in the lower court's determination that plaintiff was entitled to fees under a proposal for settlement by using the full amount of the verdict. And by way of background, the 4th District in 21st century says this is why the judgment was entered this way because Fridman says so. But no one was arguing otherwise in Fridman, and it was dicta, and I believe it was there to explain why we're dealing with a strange judgment that's in one amount but only executable to a lower amount. But ultimately what 21st century held is completely consistent with what we're arguing here. They said you can't compare the full amount of that judgment to the PFS. You can only compare the policy limit to the PFS because that's the only enforceable judgment right now. That's exactly what we're saying. The only judgment that should be enforceable right now is the policy limit. And the 2nd District tells us that that's dicta because had the judge in the 21st century case entered the judgment limited to the policy limit, it would have been the exact same analysis. We'd apply that number in comparing it to the PFS. Vinson tells us two things about, and I know you're not bound by it, but it's true and it's correct. Vinson tells us two things about 21st century. One, they use some loose language in describing Fridman. It's true. But it didn't matter because it's plainly and clearly dicta. It had nothing to do with the outcome. The holding of 21st century is In this posture, when you have a judgment against an uninsured motorist carrier following the first trial, when its liability is only limited to the policy limit, that's the number we use to compare to the proposal for settlement for fee purposes. It's good law. It just has some loose language in dictating it. And of course, it's the correct rule. I mean, again, there's no authority for, the idea now, it's funny, because up until now, we've been told Fridman requires this judgment that was entered. Now we're being told, well, Fridman didn't require it, but it's okay under Fridman. It's not okay under Fridman. Nothing in Patton or Fridman or any other authority says you can enter a judgment against someone for more than what they owe. Going back to the trial error, I think, counsel's argued a lot of things about Murphy. I'm not arguing Murphy. I think there were two objections. I think they were adequate during the cross-examination of Dr. Von Thron. Certainly enough to put the judge on notice of what the problem was. We've heard a lot of speculation and theory about maybe these numbers were good, maybe they were good for JOI pertaining to work that Dr. Von Thron had done. There's no evidence of any of that. Dr. Von Thron was asked, isn't this the amount of money that you made? Not what JOI made, not what JOI made because of your examinations. It was, isn't this the amount of money that you made? It is, here's a tax document that shows that you did. Okay, so all this theorizing that maybe these numbers were legitimate, there was never any evidence that they were legitimate. And in fact, in the answer brief, we were told that this is the result of confusion and it was all cleared up. Now we're hearing today that maybe they were good numbers to begin with. There's no evidence that these were good numbers. Dr. Von Thron was accused of having earned $400,000 personally from State Farm. There was never any evidence to back it up, and it was reiterated in closing. And it was improper. I understand the reluctance to grant a new trial, but that was improper cross-examination. And when he should have known better at that point by closing, it was violated. So again, I would ask that the court reverse for a new trial, or at the very least reverse under all the authority we've talked about for a judgment that's properly limited to the policy limit. You can have the number in it, just like Fridman authorizes, but it shouldn't be a judgment against State Farm for $4+ million at this point. Thank you.
Thank you, counsel. Thank you both. Well presented. We are now officially in recess.
All rise.